Our next speaker, I'm just taking a look at what the title of his topic is well known, I think, to everyone who practices in Toronto or even purports to practice in Toronto, is Julian Porter, QC, who is extremely well known as a civil litigator for many, many years, and particularly well known in the area of libel and slander. His topic, People Are Starting to Sue for Libel, How Strong Can Your Letters Be, is one of very, very great importance, I think, to all of us. Mr. Porter is obviously a Queen's Counsel. He has practiced litigation exclusively for more than 30 years and is a specialist in civil litigation. My connection to Mr. Porter goes back perhaps 10 or 12 years when I was a very junior person sitting in the room with him and I believe Charles Scott, and it involved some potential litigation over libel and slander, and I remember being astonished at the fact that the two of them could sit down. Mr. Porter knew the law absolutely intimately, and in a space of about 5 minutes, and I don't know if he'll even remember this case, resolved the whole thing. He's a man of tremendous erudition, and I think will give us a very interesting talk on what is an extremely important topic. So I'd ask you to welcome Mr. Porter.
Well, I don't know about the erudition, but I had last week, after 30 years in litigation, I'm a little punchy today, but I had a discovery in Moscow. And the discovery was either going to be in Belgrade or Moscow. And I took Moscow. And so it was a huge cultural change. And, you know, law is sometimes a wonderful profession. You're actually paid to go over to Moscow, conduct an examination, and so as a result, I'm suffering vast jet lag, which will be an excuse for my being inept. And I know you'll note it. Now, it is tough practicing law, and I find after 30 years, to my amazement, it's still as tough now as it was 30 years ago. I thought by this time I'd be on easy street. I'd be advising large corporations as to whether they could be bought and sold. Shell Oil would be phoning me. Well, other than if my furnace is broken down, Shell Oil doesn't phone me. And so what amazes me is that clients now are difficult and make life for you and me very difficult. And so always with the first interview, one of the problems with being a litigation lawyer is that you are by your nature insecure. You never know. Your calendar is never filled up in advance. You pretend it is. But it's really got a whole series of potential dental appointments. And so you meet these other people in the corridors that tell you they are busy till next March. And you either think, you lying bastard, or worse, they are busy till next March. And so I still look at this speckled, vaguely nude calendar, and I suffer great angst. But inevitably, things fill. And so your problem comes as a lawyer that the client comes into the office, and more than half of the clients are now yellers and shouters. They didn't used to be, but they are now. And they first ask you right off the bat, are you tough? So you're basically may have a slight hangover, and Yes, I'm tough. Well, you better be tough, because if you won't do it, I'm going to get a tough Jewish lawyer. You think, well, now, wait a minute. I better not bring up the Human Rights Act and all that. And I've got a great case that's worth millions of dollars. And if by that point, you don't say something, you're starting to get into trouble. Because when you say nothing at that point, then there's an assumption there that he or she has a good lawsuit, and you've said nothing about it. And you should speak then, and you must be careful. The hard part of litigation is that you really are there as an advisor. And I must say that if I am critical of some of my friends throughout the litigation bar, is I'm most critical, perhaps unfairly, but I'm most critical of lawyers that have accepted briefs and $75,000 later say to the client, having gone through a long process, we should settle for next to nothing. Because I think in many of those instances, $75,000 could be saved. And it's very difficult at the first interview to say to somebody, no, our legal system is too expensive. At the end, this is not a way to make money, for sure. This is like the penny mining market. Because for that advice, you can't get paid. Really, it's the best advice they may be ever given in their life. But you can't get any money for it. But that's your job. So this is sort of pertinent because when the client starts to haggle, and they haggle, and they say, well, after you say, look, if you take a lawsuit and it goes through there and you may not succeed and you may not be able to get costs and be great, well, why don't we send a letter? We'll just scare the crap out of the other side. And so then you begin to negotiate a fee. What would a letter be worth? And you look at the person and you ask what they do. Well, I'm a clerk for Simpson's. My dad is head of a real estate company. And he says I should go to you because you'll do it pro bono. Ha! So you do write lots of letters, which are meant by the client to be in terrorem letters. And clients, when you get into trouble for sending this letter, they will hold your coat when you're in the boxing ring. No more than that, they'll be waving and boom, boom. So be very careful when you send nasty letters. And let me give you a typical example. And the law isn't easy, and I've set some cases out, and it's not easy, and you got to be careful. And so, and recently there's been a vast increase of litigation over lawyers' letters. And on behalf of LPIC, I'm seeing all kinds of it, where 10 years ago, people weren't suing over this, and either people are getting more aggressive in the letters that they're sending, or they're indiscriminate, or the words or they're trying to act in terrorem. So please be careful. So just as a first rule, if you're asked to send a fierce letter to somebody, spend a day thinking about it. Really, don't. Because the interesting thing is when the client comes in, so help me God, after all these years, you believe what the client says. You believe what the client says. You never cross-examine the client. And if you do, the client says, I'm telling the truth. And you think, well, he's telling the truth. Porter's first rule. If a client in the middle suddenly says, honestly now, ding. If a client ever says to you, I'm truthful, ding. The best thing in cross-examination is halfway through suddenly, Your client says, well, honestly now. So, client says, Smithers, he used to work for me. He's gone to my competitor Jones. He's stolen our files. He's taken confidential lists of customers. He stole from me $4,000 in that he improperly charged expenses, and he sexually assaulted my secretary. You have no way of really questioning that, because you've got the one meeting and he wants something to be done, and somebody's just left and gone to a direct rival. So you got to find out if the new company is a direct rival. You can't really examine into the $4,000. You certainly can't examine about the sexual assault of the secretary, and you can look with some specific intent as to what files were taken. So you can look into that, and you've got to make, of course, a decision about whether this is a confidential business and whether the files are in fact confidential. Well, that's a little bit of common sense. So then he says, I want you to send a letter that'll scare them. So you do. Well, first, remember Shakespeare, too hot, too hot, too hot, the mort of the deer. Don't send a letter when you're hot and he's hot. And it makes no difference that you dictate that letter in his presence and he approves and says it's correct. That doesn't make any difference whatsoever. Makes you feel better. It just means you'll both be defendants later on. So you write to Smithers, who stole the stuff and stole the files. So first of all, most lawyers write a letter without prejudice, headed. That is the daffiest thing that ever happened in this life. Always send your letters with prejudice. Because they're like, what does with prejudice mean? It means the first thing they got to go and see a lawyer, which is so send them always. If you really want that letter to ever surface anywhere else, head it with prejudice. So you send the letter to Smithers. You say, in essence, dear sir, you're now working with Jones and Company. You're to return to your ex-employer $4,000, which you stole. You're to return the confidential list, being which you took from Mrs. Mercer's cabinets, and they're our list. And you are to apologize to Melanie, our secretary, for sexually assaulting. If you just send that to the person alone, it may not be publication in law. There's some old-fashioned stuff that if a secretary sees it, but that may be, but no. Everybody wants to put copy. Copies kill you. Don't ever send copies, and if you do, make it a blind copy. I had a temporary secretary one day, and I was sending out a blistering letter, and I said blind copy to 3 people. I was in a hurry. I pretended I was going to court, but I was going to play tennis. What I say in my messages, Mr. Porter's in court. They say, ooh, very busy guy. So the letter went out, fierce, and it headed on the bottom, blind copy to Jones Smith Biagio. So you send a copy to the new employer. You send a copy to the secretary that was assaulted. Why not? You want to sort of get everything down. You might have told people you were going to do this. Well, in respect to that letter, the new employer has no business knowing at all that Smithers stole money from the old employer. That's not in any way privileged. I mean, the concept of privilege is that you have an obligation and a duty to write on behalf of a client to somebody that has an interest in law in receiving it. And so it's the only, you can obviously write Smithers, and you can say quite strong things to Smithers, because he's the person that's left, and you want the money back, and whatever. So the one thing that the new employer is entitled to hear about is the return of the lists, because if you do have litigation later, you will be suing Smithers and that new company that has the lists. Nobody has any business whatsoever in knowing about a sexual assault. And it happens all the time, that the copies you send, and I can't tell you, I think I've had literally 10 cases which we've had to pay some money on because the letter isn't focused. It's got 3 or 4 things in it, and the recipient is only entitled to know about 1 or 2 of the 4, and you always say we've got a perfect case, and you end up settling. So there are 2 concepts of law, and I put a couple of cases in there and reproduced them on purpose so you can read it and see, and maybe I'm being too much of a nervous Nelly. It's possible that I am, but be careful with the letter, because usually, why are you sending the letter? And if you're lucky, and if you're close to litigation and the recipient of the letter might either be a party or a witness, you may very well be subject to absolute privilege. And absolute privilege means you can do any damn thing you want, and you can be malicious, and you can do all kinds of stuff. But if it's only qualified privilege, and that is where you must satisfy a judge that you as a lawyer acting on behalf of a client had a duty in law to communicate to somebody, and you only sent it to that person who had an interest in law, I don't mean curiosity, an interest in law and receiving it, then that is qualified privilege. And qualified privilege then means you have to have a whole lawsuit to decide it. Because qualified privilege can be destroyed if you send it to people that have no interest in law in receiving it, or you say words that are not appropriate to the occasion, or you write things which you know or really ought to have known aren't true. So suddenly, if you have and libel's simple. It's the defenses in libel that are difficult. But you can tell. A corporation can be libeled, a person can be libeled. And any words to that person's discredit. So you just use the basic nose test. If you think, ooh, gee, wouldn't want to deal with that person, you've got a libel. It's not hard to see what's a libel. False words to someone's discredit. And corporations can sue. Their damages may be different, but they can sue also. And any group of people less than 12 can sue. You can't have a huge class action, so you could libel an entire religion or things like that. And then it's whether the defenses work. And the defense of absolute privilege is, as for instance, if you are in court or if you are in the legislature and you speak and do something in court, in our jurisdiction, it doesn't matter. You can say anything you want. You may have consequences in costs, but you can cross-examine and put terrible things to people. The judge may stop you, but nobody can sue you. However, you got to be careful, and it's the same for an examination for discovery once actions have started. But there is a case that I've cited in there, Gutstadt and Reininger, where there's an examination for discovery, there's a court reporter, and a libel is the written word, slander's the spoken. There are not that many slander cases anymore, but it's all the tort of defamation. So on the discovery, any question asked or anything asked is fine. That's absolutely privileged. So the discovery goes on, a document's produced, and a client is sitting there and his lawyer is sitting there, and the court report, and the opposing lawyer. And the opposing lawyer finishes the last question and says, that's the end of my discovery. And then he looks at the reporter, kind of sitting there, typing and closing up the thing, says, God, that document you just produced, that's a pretty recent document. Wonder how the hell that document came about. I wonder who fixed up that document. Has to be somebody in your client's office. And so the court there was the argument, and so that was published to the court reporter and to the client, because they were talking about a client's partner. So you're talking about that some other lawyer had fixed or fribbed a document or forged it, and to the lawyers. It's only published to 3 people. And so on a motion that this was absolute privilege, this was just as if it was part of the examination for discovery, Mr. Justice Day, maybe it wasn't Day, but somebody said, no, McComb said, no, at best that's qualified privilege, because the courts are not keen to expand absolute privilege. Because absolute privilege is absolute privilege. You can't do anything about it. And so absolute privilege most probably does extend to when you go to interview any witness. And especially if litigation started, and generally I think the law, which I've set out there, shows that if you are on the eve of commencing litigation and you're interviewing people, that's fine. That'll be absolute privilege but I want you to look at those cases and look carefully, because in all that process, what happens, just remember, when you go to interview somebody, how it's going to trickle back. You're interviewing somebody and say, look, I represent Canadian Tire, and we gather that you've dealt with the general manager of the branch store, and we are suing him for stealing money, and I wonder if in the transaction concerning the purchase of this, I'd like to see the contract, and I'd like to see if there's some evidence that you were aware that he was stealing money. So then it gets back. It gets back because the person then phones and says, Harry, do you know what they're saying about you? They're saying that you've stolen money. I think you can do that. But what people like to do in any litigation is to start a lawsuit for libel. Because first, the other side says, if I sue the lawyer for libel, I'll get him off the case, and he's an awful pain in the ass. And secondly, it'll just divert everybody, and they'll want to settle. So you can, of course, go and interview people, but try and be careful. And try and be careful where you send your reports of the interview to. Now, I set out the nub of the law, and the 2 cases are at 10-7 Lubarovich, and this is a judgment of Mr. Justice Lane. And there is a couple of, and this is a motion as to whether to strike it out, whether the activities here in a letter sent to a proposed defendant trying to stop money moving to the plaintiff was absolutely privileged or qualified privilege. And of course the difference is, as I said, if it's absolutely privileged, that's the end of the matter. Under Rule 20 or 21, the judges say stop, which Lane did. But the first interesting concept at 10-10, and you should always remember this because people always sue lawyers for negligence, the other side. There's no duty. You see page 1010, negligence. In the absence of special circumstances, of which none are pleaded in this case, a solicitor owes no duty of care to the opposite party, and no action and negligence lies against the solicitor. So we may all sleep easy at night. It's only if you're negligent to your own client that you can be negligent as you wish to the opponent. So, and it also goes through the concept of inducing breach of contract, because in a lot of these torts, they sort of blend about 9 other torts. And so Lane found in those circumstances that that letter written to somebody that was going to be a proposed possible defendant who was holding money which was vital in the matter, and the solicitor acting for the plaintiff had to tell the bank to hold the money and had to set out some reasons, and wherein she said in her letter, I think there's some fraudulent stuff going on, and so the lawsuit was commenced. That is really, along with, that is sort of the high point. The other cases that I put, Fuss and Fidelity, is where a lawyer became a trustee in bankruptcy, and there was existing litigation, and he was sending very strong letters to proposed creditors, and the trial judge found it was absolute privilege, but the Court of Appeal, which I've set out at 1021, says the sort of chilling thing was that, well, we're not going to give it absolute privilege because it wasn't really part of the court stuff. You got to just watch that, and that's what I'm asking you to watch it, and I'm asking that you really focus on why you should send a letter and what the letter will do, and if so, keep it tight, keep it to the facts, think who is receiving the letter and what's pertinent, and there may be different letters going to different people. And you may, if there were 3 separate allegations, you make sure that you don't cross over and have an allegation that it is of no interest in law to the new employer whether your client sexually assaulted somebody or whether stole money from you. The only thing that's of interest in law to the new employer is whether he's pinched lists and the new employer has the lists. And so I could only lecture in that so much. But today there's another terrific trend, absolutely wacky trend, and I've had about 5 cases, and people now have press conferences. Mother of God. And there's a new rule, which I'm a recently elected bencher, and I want you to look at 10-4. And fortunately, the usual allegation they make against me is that I do very little. Well, look at George Bush, where I got him. But occasionally I vote for propositions that I wonder whether I wasn't a little soft in the head. In 10-4, there's a new rule, just started on November the 1st, provided that there's no infringement of the lawyer's obligation to the client, the profession, the courts, or the administration of justice, a lawyer may communicate information to the media and may make public appearances and statements. And there is really a very good argument made that mostly in criminal law, the police, there's Jocko Thomas from police headquarters, and then they go and or on television they show the Peel regional police chief, and he's got all these braids on, and God, it looks as if he's been in Korea, the Boer War, Second World War, and they're a great mass of guns. And then there's white powder, God, it may only be, and they say, from information received, you look at from information received, we went and arrested Harry Jones, who lives at 34 Sussex Drive, and then list all the offenses of the criminal code, and somebody in the press says, well, can you tell us what section 232 of the criminal code? Oh, yeah. So then the lawyers say, hey, if I'm acting for an accused, I should be able to sort of meet this stuff right away, or there's no point. And we as a law society don't have any control over what the police say. So we pass this rule and we'll have a look at it. And it may reflect what a number of lawyers have been doing over the years anyway. So now you are entitled to make public appearances and statements. And so this, in essence, allows you to say that I believe in my client's innocence. But that and $2 will get you on the subway. Because if you get in front of a judge, that merely means you cannot be professionally disciplined. But it doesn't mean that if you say something in a press conference that's at all libelous, that this will give you any protection whatsoever. And most of the judges will think this is a silly rule anyway and wish to do something to you. So please, if a client asks you to have a press conference, or you feel that the realm of your practice will expand, if what you say should be on the front of the Windsor newspaper, and if you lean back and think you'd like to opine about the evidence that's going to come up in this case, and when the reporter says, have I got it absolutely true? Well, you do. You have it absolutely sure, and I'm saying that the witnesses for the prosecution are just not telling the truth. Ding. And then the newspaper reports it. The newspaper, of course, they can report a lot of things, and there's lots of law as to what newspapers can report, but you as a lawyer never have any excuse for being part of a press conference. And I unfortunately have done it myself, by the way. And so it's not as if but I was careful. Well, I guess I appeared in a press conference attacking the CBC, and that's sort of easy to do. But there's a great temptation. I'm not saying when you're in court and making an argument and the press come and say, can you please explain what your argument is? Sure, you do that. You be careful. But there's, in terms of a press conference, if your client asks you to do it, they want you to crap on the other side. They really do. Otherwise, there's no point in having a press conference. None whatsoever. So no use saying to the client, we don't have enough money for saturation. We better put it on all better. And I've known there have been cases where lawyers say, we're going to issue a statement of claim next Monday, and there'll be a press conference in my office at 12:30 after we file a statement of claim, thinking, now the new law is that once a statement of claim is filed, the press may report on it, provided they make it clear it's only a statement of claim and it's untested. But it doesn't say that a lawyer can go out and say, I filed the statement of claim and I believe everything in it to be true. That's suddenly outside of the pleadings. And you and your client are exposed, and then your client will be sued too, because your client's bound to be standing next to you, and he'll say, yes, and do you agree? And I guess I'm aware of about 5 cases with press conferences. And quite a bit of money has flowed from those cases. So if somebody asks you to do a press conference, please don't. Any questions? Yes.
I have my questions to the press conference that she held. Now, we did attend the press conference, but didn't speak at it. We're available to explain to the press what was being needed to claim, and nothing further. And we actually thought that that would be helpful to make sure that things were accurately reported and that things didn't get carried away by either our client or the press. And I wonder if you think that's
watch out, because all these rules you have to shift. I mean, it's fine for me to opine and sort of make these absolute rules, but if the person's bound and determined to have a press conference, you certainly got to give them a talk about the law of libel, which they will not understand. Nobody, you know, oh hell, there's no damages. I've heard it all over town, just passing it along. And if you're there, there will certainly be the inference that you may have approved it. It's tough, but you kind of have to be there if the person's going to go and have the press conference, because you may have to do some sort of damage control. So I don't think you have an easy position, but you certainly will make very clear that if she makes some, if the client makes some statements, you make it very clear that this is merely your client's allegations, and this is early on in the matter, and there will be a defense. But if you tell the client you're going to say that, they're not going to want to have a press conference. So, yeah, if you're not there, knowledge is power, and knowledge may be liability. Glad I helped you. Yes.
There's a lot of nasty letters between lawyers.
Yeah.
Often it can be in front of the court or even before, it can be after the settlement falls apart. And
Yeah.
go back and forth blaming each other. You lied about this, you lied about this, you lied about that.
Yeah.
Can that be the subject of libel actions?
Yes, it could be, because was probably distributing it. There is they had to settle something where somebody wrote a judge after a decision. And, you know, judges are functus, and unless the judge asks you to write, and there is a great tendency to get snarly in those letters, and if it's just lawyer to lawyer and not to anybody else, even though secretaries may see it, I think you've certainly got to, if you're going to get into that stuff, I believe it's a mistake, but certainly the letter should be marked most confidential and for that person alone.
This is a related question. If you get a nasty letter, is the best approach to ignore it, or do you have to respond? And if by responding, are you somehow waiving a right to complain about the letter?
Well, complaining to the Law Society, what do you think we're going to do? There's nothing more irritating than in the middle of a case. Usually some guy that's about a third of my age says, I'm going to report you to the Law Society. You know, it's sort of an annoying, so my guess is that you most probably write back a letter saying, I don't view that your language is appropriate, and it isn't assisting the clients, and I'm not going to get into a pissing match with you. And spell pissing correctly. Yes, Mr. Harris.
Thank you. When you speak in something, it's, as you say, it's slander. When that spoken word is printed in the newspaper, it becomes
Libel.
If there is a television camera,
That becomes libel because of the act. They just call it libel. Yes.
Are all pleadings that you prepare on behalf of the client subject to the absolute privilege?
Yes, but, God, this should have been the center of my lecture, and I think I've forgotten it. It's Moscow Blues. You do a pleading, you file it in court, that's absolutely privileged. But I don't believe that you are entitled as a lawyer, as a person that's prepared that pleading, or your client, to shovel that pleading around and distribute it to other people. They can go to the court and look at it, or get access, or all those rules. Because inevitably, your client will say words to the effect, will say words outside of the pleading, that say that pleading's absolutely correct and we're going to win. and you will say something to that effect. So you file it in court, and if you're being safe, if the press phone you and find out about it, you should put the press on how they find the pleading in the courthouse. And there is a rule where if the press requests you for a pleading, it's in one of the regulations. You may send it to them, but I think it's very dangerous if you have a pleading that's in its nature libelous for you to be phoning up the press or distributing it, and just because when filed it's privileged. It's a very dangerous thing. Once, of course, it's in court and argued in court, then that becomes a different matter. But what somebody's going to try to sue you for in order to derail your litigation is words you've said accompanying. You'll send a letter and say to somebody, I just wish you to know that Jones is being sued. Here's a copy of the statement of claim, and we're most confident that we will succeed. It's the most confident that we'll succeed. Okay, have I answered it?
I think so. So basically what you're saying is as long as you just prepare it.
Oh yeah, there's nothing wrong.
Then you got no problem.
Absolutely none.
Other statements about
You can be negligence in the preparation. You can include in affidavits, unfortunately, abusive, scurrilous stuff that you must probably know isn't correct. And provided it's in the affidavit and it's filed in court, the most that may happen is you'll suffer from costs. But that's what absolute privilege is about. Mr. Morton, have I said something that you think is not correct? I can see by that look I have.
I shouldn't say that.
Would have been helpful if you'd raised this before I started.
I would necessarily defer to you on any
you
point.
Regret
but
to it.
if in fact there is some case law that if in fact you knowingly permit a false affidavit to be filed, you may be subject to a claim for abuse of process.
Oh, well,
which is a nice lead-in to the very next topic.
I'd like to. That may well be so, but it's not to libel, and
no.
I better listen to the next lecture. Thank you very much.
One of the things I've always told my thin client base is that when you're in court, be completely unemotional and show no expression at all, and clearly I can't follow that even when I'm sitting at the front of a room. Our next speaker, who will be talking, as mentioned, on the abusive process topic or subject, is Paul LeVay, who is a partner with Starkwood Spees and has been for some time. Mr. LeVay is the managing editor of the Advocates Society Journal, and is a member of the board of directors of the Advocates Society. He has published numerous articles and spoken at many conventions and conferences. He is certified as a specialist in civil litigation by the Law Society and has legal degrees both from Osgoode Hall here in Toronto and from Strasbourg in France. And having said that, I would ask you to welcome Mr. LeVay.
Thank you, James. When I found out that I had to follow Julian Porter on the schedule, I tried to pull out, but it was too late. So pardon what might be a somewhat more pedestrian presentation of the topic of abusive process. Now, abusive process is a very broad topic. The term is used in a variety of contexts and may be found in at least 4 rules of civil procedure and has developed in a number of different jurisprudential doctrines. What all of them have in common is this: they attempt to prevent the mischief of the use of the civil process in a manner or for a purpose other than that for which it was designed, and that's namely the fair, just, and final adjudication of real disputes between litigants. It's, of course, critical that sufficient rules be developed in this regard because it's really fundamental to ensuring that there is faith in the rule of law, that the system works, and that litigants don't become jaded and cynical, or at least any more jaded and cynical than they already are about the process. Now, in our paper, you'll have noted that we reluctantly conclude that in many cases, aspects of abusive process are more theoretical than practical. And lest you think that that's being unduly pessimistic, we do say that there are ways in which the doctrine is being applied creatively and practically, and that's particularly in the area of avoidance of multiplicity of proceedings, about which I'll speak to you in some detail this morning. And finally, in our experience, and notwithstanding the kinds of counsel letter that Mr. Porter outlined, the majority of counsel are not practicing in an abusive fashion, and the rules are effective in the extreme cases. Now, we've divided this big topic into three parts, and I'll touch at least on all three of them this morning. The first is the doctrine of abusive process, and that's really the avoidance of multiplicity of proceedings and how has the law evolved in that regard. The second aspect is the tort of abusive process, and that's where otherwise legitimate proceedings are being used for an improper purpose. And the third aspect is quite simply the broader principle of abusive process, and that's the mechanisms, particularly in the Courts of Justice Act and the rules to prevent litigation being conducted in an abusive fashion. Now, the first type of abusive process, and that's to do with avoidance of multiplicity of proceedings, often arises in the context of a motion under Rule 21.013 sub D, which allows a judge to stay or dismiss an action on the grounds that it's frivolous or vexatious or otherwise an abusive process of the court. The basic issue is whether a decision in a prior proceeding has addressed and disposed of all or part of the subject matter of the current proceeding, such that it wouldn't be right or just to allow the proceeding to continue. And the doctrine is defined in this way by Mr. Justice Ground in the Reddy and Oshawa Flying Club, and this is at page 2 of the paper, I believe, that the doctrine of abusive process is somewhat similar to the doctrine of res judicata in that it also seeks to prevent a multiplicity of proceedings or the relitigation of an issue determined in earlier proceedings or which might have been raised in earlier proceedings, but the party now raising the issue before the court chose not to do. And his point was that the litigant should be prevented from abusing the court process in attempting to put forward again issues which were either raised in the first action or which were known to them and left unraised at the time of the first action. And there's the two aspects to it. So that allowing them to do so is to permit a duplication of proceedings with the inherent danger of conflicting findings of fact on identical issue, which is, of course, an important mischief that the doctrine seeks to prevent. Now, as Mr. Justice Ground raises the issue of res judicata, it's important to remember that there are two forms of that doctrine. The first is cause of action estoppel, and that's where claims or liabilities have been determined. If the judgment in the first proceeding has been given for the plaintiff, the present claim is held to have merged in the judgment, and if the first action was dismissed, then the present claim is barred. There's also, however, issue estoppel, and that's where the focus is on the issues rather than on the entire cause of action. And that's, for example, in a negligence case where the standard of care issue may have been determined, and I'll come to an example of that later, but issues such as duty of care, causation, and damages haven't. Now, why do we need the doctrine of abuse of process to prevent multiplicity of proceedings where we have the principle of res judicata? Well, the reason for that is that the Supreme Court of Canada, in Angle and Minister of National Revenue, has set out the elements or requirements for issue estoppel, the res judicata type of issue estoppel. And those elements are three. First, that the same question has been decided. Secondly, that it's been decided in a final manner. And finally, that the party to the decision or their privies were the same persons or parties to which the proceeding in which estoppel was raised is an issue. There's a mutuality of parties. And so the doctrine of abuse of process is important because you have to revert back to that rather than issue estoppel where one of those three elements are missing. And the element which is usually missing is the mutuality of parties. Now, in the United States, and we give you an outline of this again in the paper, non-mutual issue estoppel has become quite developed. And the question of non-mutual issue estoppel in the United States and how it might impact or interact with our jurisprudence is canvassed quite thoroughly by Professor Gary Watson in a 1990 article in the Canadian Bar Review, and then again in last year's or the 2000 edition of the rules that he edits. And so I'm only going to go through things in a very summary or cursory manner, but if you have a case that relates to this issue, I'd commend both of those things to your reading. Now, there are two forms of non-mutual estoppel. The first is defensive preclusion, and that's where the prior decision is unfavorable to the party to the first proceeding and is being used to prevent relitigation. And under defensive non-mutual estoppel, the new defendant can raise an unfavorable judgment to prevent the unsuccessful plaintiff from making a new claim against him. However, the plaintiff cannot use a judgment against a new defendant in the converse manner because the defendant hasn't had his or her day in court yet. Offensive non-mutual estoppel goes further. The new plaintiff can use the judgment favoring plaintiff number one against the same defendant in action number two, even though that first plaintiff wasn't party to the second plaintiff wasn't party to the first action. And there are obviously risks and potentials for abuse in this, and so the American courts have set out some rules or safeguards to which offensive non-mutual estoppel applies. The first one is that it's not available to wait-and-see plaintiffs. That is to say, plaintiffs who could easily have joined in the first action but sat in the sidelines and didn't take the risks and waited to see whether the first plaintiff would win. If the court determines on the facts that that's the situation, then you can't take advantage of offensive non-mutual estoppel. The second test or safeguard are a series of fairness concerns, and there are really three. The first is if the first action is nominal, in other words, if what was at issue wasn't really all that big or important, particularly in terms of money, such that the defendant might not have put all of her efforts into a vigorous defense, then the doctrine won't apply. The second fairness principle is if the judgment relied upon is itself inconsistent with another favorable judgment in favor of the defendant, then, in other words, if you have prior conflicting judgments, then the doctrine won't apply. Now, there's an interesting application of that in an Ontario case that we'll come to a little later. And the third fairness concern is that if there are procedural opportunities available to the defendant in the second action that defendant wasn't able to avail him or herself of in the first action, then the doctrine doesn't apply. And there's an interesting example of that in an English case where rules of cross-examination were such that the defendant couldn't cross-examine certain witnesses in the first trial, but could in the second, and on that basis it was held that it would be unfair to apply any kind of estoppel to the defendant. Now, as I've said, in Canada, the Angle case prevents the direct application of these non-mutual estoppel cases. And Mr. Justice Laskin, in a fairly recent decision, the Court of Appeal called Minot and O'Shanter Developments, makes it clear that non-mutual estoppel is not the law in Ontario. But the courts have been considering the factors outlined in the U.S. cases on a fairness basis and applying them by analogy when determining whether or not abuse of process should apply. And as I said, an interesting example of this is Madam Justice Bonato's decision in a case called Voss and Hospital for Sick Children. And since it's not in the paper, I'll give you the reference, which is 1998 Ontario Judgments 4369. Now, that case was one of the Red Cross blood cases, and that's significant because these questions of issue estoppel or abuse of process in the context of multiplicity of proceedings often arise in these catastrophic tort litigation situations. Plane crashes, big medical cases like the blood cases. And in the blood cases, the potential for problem was compounded by the decision in Sutherland, which denied certification of a class proceeding. And therefore, the way that this litigation was to be resolved was rather than a class action, you had multiple case-managed separate actions. Now, Voss was preceded by a case called Osborne, in which Mr. Justice Borens, when he was sitting on the trial bench, considered the same negligence issues against the Red Cross that came up again later in Voss. And he found for the plaintiff on those negligence case issues. And so when the Voss case started, the Red Cross essentially pleaded denial of those very same issues in its statement of defense. And so the plaintiffs brought a Rule 21 motion to strike those portions of the defense. And that was on the basis that Mr. Justice Borens had found against the Red Cross in the Osborne case. The focus of the issues in question was the standard of care issue in negligence, and particularly the issue of the Red Cross's blood donor screening processes. And on the motion, the plaintiffs framed the issue as an abuse of process issue, while the defendants attempted to cast it as an issue estoppel issue. And why was that? Because the defendants knew that if they could frame it that way, there was no mutuality of parties, and so ergo they would succeed. And what Madam Justice Bonato did was analyze the issues in terms of issue estoppel, but to decide the case on an abuse of process basis. And so going through the elements in Angle of what constitutes issue estoppel, she looked first at whether the same question was an issue. And the Red Cross argued that it wasn't the same question before the court at all, because the donors that gave the blood in this case would necessarily be different donors from the donors that gave blood in the Osborne case. And the answer to that was really to analyze the negligence suit in terms of a breakdown of the elements. And she said you have to look at it in terms of standard of care and causation. And on standard of care, the only thing that's really relevant is the screening procedure, and the screening procedure was the same in both instances. Of course, when you go to causation, there are going to be different facts, and there's no issue estoppel there, but vis-a-vis the screening processes, there are. And just as an aside, an indication that all of these facts are decided, all these cases are decided on their facts, is there was a later case, blood case called Robb, which was decided by Madam Justice Ellen MacDonald. This argument was tried on again by the plaintiffs, but the Robb case was a hemophilia case. And so the blood screening procedures with respect to the AIDS cases were much different, the court found, than with respect to hemophilia, which is a secondary blood product. And so the issue estoppel argument failed completely in Robb for that reason. Now, there was no issue that in back to Voss that the decision was final, and so mutuality of parties was where the judge went next. And after discussing the U.S. concepts, she makes clear that non-mutual issue estoppel is not a subject that's been embraced in Canada. Rather, you have to look at it in terms of abusive process. And then she goes through to consider the kinds of policy arguments I discussed a few minutes ago that can be raised to try and block the argument by a defendant. And the Red Cross argued that in this case the plaintiff took a wait-and-see approach, and so on the wait-and-see doctrine the motion should fail. And the judge pointed out that these actions were case managed carefully by the court. And in any event, and this is important, the wait-and-see argument in Ontario has not been met by a denial of the issue estoppel decision, but rather by a sanction and costs. And there's a case called, I'm going to butcher this, Germschein and Valois, which makes that case clear. Now, the defendants also raised the second policy argument we discussed a few minutes ago coming out of the U.S., and that is where there are two prior decisions and they're inconsistent, the doctrine shouldn't apply. And of course, prior to the Osborne case was the Pittman and Bain estate case. And in that case, the blood screening procedures were examined by Madam Justice Lang and found to meet the standard of care. And so the defendants in Voss said, well, you have Pittman that says the standard of care was met and Osborne that says it wasn't. They're conflicting decisions. We have to be able to litigate this again. And what the judge did was carefully analyze the chronology of events, making it quite clear that the Creever Commission intervened between the Pittman decision and the Osborne decision, and said the Creever Commission really clarified a lot of things that were unclear at the time of Pittman, and all of the facts were on the table by the time of Osborne and were fully litigated, so that argument just doesn't stand. And Madam Justice Bonato concluded by saying that the court has, in my view, the obligation to step in and prevent a clear abuse of its process. To relitigate issues which the Red Cross has fully litigated and lost would amount to such an abuse. It would, in my view, be unconscionable to require the plaintiffs to reproduce the evidence and arguments made in Osborne with respect to the standard of care issue. This is an example of a situation where it would be an affront to one's sense of justice and would cause an outrage by a reasonable person to require the plaintiffs to relitigate these issues. Let me speak now for a moment about the second aspect of abuse of process that we discuss in the paper, which is the tort of abuse of process. And that issue is dealt with on pages 8 and 9 of the paper, and we give you an example of a hypothetical fact situation which may, in theory, and I emphasize in theory, give rise to an action for the tort of abuse of process. Because in the tort of abuse of process, it's not the merits of the action itself that are in question. You may have a perfectly good cause of action against somebody or a perfectly good reason in law to sue somebody. It's just that you're doing it for the wrong reason. You're doing it for a collateral purpose to gain an advantage other than the win in the lawsuit. And the example that's given in the paper is where a developer sells a builder a piece of land, the price falls in the interim, the builder doesn't pay, the builder registers a certificate of pending litigation on the land for the purpose of trying to force the developer to lower the price and sell out and resolve the matter. Clearly an improper collateral purpose. The problem is that the builder does have an interest in law in filing the CPL. So on its face, the action may not be a winner, but it has a valid legal basis. And how do you prove the intention? That's the problem. You really have to kind of win the lottery. And sometimes, let's just take another example, which is a common variation, in my view, of the tort of abusive process that you see all the time but you can't do anything about, is a corporate officer or director is sued for the purpose only of obtaining discovery. You don't really care about succeeding against the person, but you want their discovery, and if you just sue the company, you get one person and everybody else by way of undertaking, and you want two people. So you name the person. Naming the person just to get their discovery is an abusive process. But unless you can catch somebody out saying it, or better yet, putting it in a letter, you're never ever going to be able to prove it. And it's the same thing with the hypothetical fact situation that we raised. So it's a nice cause of action in theory, but I don't know if Mr. Porter has. I never yet have seen a successful set of facts and a successful decision on this cause of action. The final topic that we discuss in the paper is abusive process generally in the Courts of Justice Act and the rules, and we try to list the sections in the rules where the legislature or the Rules Committee have put in rules and sanctions for basically acting abusively in the course of conducting the litigation. Now, the test for a stay of proceedings on the basis of abusive process under Section 106 of the Courts of Justice Act, again, that's kind of like the Holy Grail or reaching for the brass ring that you'll never obtain. There you have to show that there's an injustice to A in continuing, and there's no injustice to B in stopping the litigation, and you can imagine the limited number of occasions on which you'd be able to convince a court of that. With respect to abusive motions or discovery, on the motions rule, which is Rule 3716, you basically have to convince a court that there have been multiple and vexatious motions, and the test that is drafted similarly to the vexatious litigator section in the Courts of Justice Act, and you have to be very, very careful about raising that kind of allegation. Normally, you really have to have been put to a number of very inconvenient motions by the same person before you can even think of raising that. Rules 3414 and 3415 provide for rules to govern or control abuses of process in the examinations, in out-of-court examinations, whether they be examinations for discovery or cross-examinations. But again, adjourning an abusive examination in order to obtain a court order rectifying the situation is something that you would do very reluctantly in extreme cases for a number of reasons. I mean, first of all, litigation isn't a tea party, and you're going to have to show a transcript. And remember, you're in the room and you feel the all of the nuances and the emotion in the charged examination room. All the master, the judge, is going to see is a transcript, a cold transcript of the words said, and you better be sure that on the face of that transcript you have the words necessary for a finding of an abusive examination and to give the judge or master grounds to offer up some sanctions. And the second reason, of course, is it delays litigation and it's expensive, so that's a barrier in and of itself. Let me just take a couple of minutes now just to take you through the outline of a case that we've described in the paper, and more for its amusing facts than anything else. So this, I think, is an example of the garden variety use of the word abusive process, and just to show you practically that there are some things you can do to stop an abusive procedure quickly, but it may be cold comfort to your client at the end of the day, or at least your client's not going to be made entirely whole as a result of being the subject of the abuse. This is a case called Altberg and Oosterhuis. And Mr. Altberg was an accountant and a member of the Institute of Chartered Accountants of Ontario, which is the governing body. Now, his client, Mr. Oosterhuis, made a complaint that a payment which ought to have been directed to Mr. Oosterhuis was intercepted by Mr. Altberg and applied to Mr. Oosterhuis's account rather than forwarded on to him. The Institute investigated the complaint. As a result of the investigation, charges of professional misconduct were made. The hearing was held, and there was a finding of professional misconduct and a penalty imposed. Coincident with that, Mr. Altberg complained to the Institute that the investigation had been unfair, and the Institute retained Mr. Ian Binnie QC, as he then was, to conduct the investigation. Now, Altberg there was an internal appeal process at the Institute by which he could appeal the decision of the discipline body, and he did file the appeal, but he failed to order the transcripts, and so the appeal committee at the Institute dismissed his appeal. And then a short time later, Mr. Binnie concluded his investigation and found that there had been no abuse of the investigative procedures. Now, before that happened, Mr. Altberg complained about Mr. Binnie's partiality on the basis that the Institute was paying Mr. Binnie's bill, so Mr. Binnie wrote Mr. Altberg a letter saying, if it'd make you feel better and that the process is fair, you can pay half my bill. And so you know what's coming, in the subsequent civil proceeding that Mr. Altberg launched against the Institute, all of the members of the discipline panel, all of the investigators, the inside and outside prosecutors, and Mr. Binnie, one of the things that he pleaded was that Mr. Binnie should be held liable for the tort of sarcasm, which not surprisingly, the defendants moved to strike the statement of claim as disclosing no reasonable cause of action, and Madam Justice Sanderson granted that order. Now, the issue of abusive process had also been raised, but Madam Justice Sanderson hadn't felt it necessary to deal with that issue. The claim was struck with leave to amend, and so the claim was amended, and a new motion to strike was brought. This time, the issue of abusive process was raised and was successful before Madam Justice McFarland. And one of the bases for the abusive process argument was that, in effect, Mr. Altberg was trying to litigate matters that he properly should have pursued to the appeal panel and then by way of judicial review. In other words, these were really bias and reasonable apprehension of bias arguments that he ought to have pursued up the ladder to the appeal panel and then to the divisional court. On that basis, Madam Justice McFarland found that it had been an abusive process. The Court of Appeal dismissed Mr. Altberg's appeal. They didn't feel it necessary to deal with that issue. They dismissed it on the basis that there was no cause of action pleaded. So the costs issues being pursued, that Mr. Altberg acts in person, and there were significant costs for a number of parties, and so the action was ultimately disposed of, but not without costs to the people who were sued. Subject to any questions?
I have a question. Do you think if they had played the tort of irony, they would have done better?
I think maybe that with my limited knowledge of Mr. Justice Binnie, that sarcasm may be more fitting.
Thank you very much, Mr. Waechter. We now have a luncheon break. When we come back at 1:30, my co-chair, Wendy Matheson, will be taking over, and we look forward to seeing you in just a bit. Thanks again.